Thank you, Bill. Welcome, everybody. I'm Michael Diamond. I'm going to moderate this discussion. For those who don't fully know how we're going to do this, we're going to do this a little bit differently than some seminars. The purpose of this program is not to have a series of lectures from our distinguished panel, but rather to have a conversation among us and to provide to particularly advocates how experts can be most effectively used and how we as arbitrators are persuaded and affected by them. Because I know over the years as an advocate and an arbitrator, I would sit and watch arbitration panels, watch arbitrations from the arbitrator side and see very good lawyers present evidence and present experts very effectively. And I learned from that, and I think it made me a better lawyer. And then I would also see people do things that weren't working and sometimes even irritated me. And I would say, boy, that's really bad. And then I'd say, wait, I do that sometimes. Better stop doing that. So our goal is to give you the opportunity to at least hear from these four arbitrators, what works for us. This isn't a guarantee or a representation that every arbitrator feels that way, but these are how we reflect it. Also, if you have questions, you'll see at the bottom of your screen, there's a question icon. And if you type in your question after the program, because I can't see them while I'm screen sharing our slides, after the official part of the discussion, I'm going to go to the questions, and we will try to answer some of them. I'm sure some will be, I can combine some. So let me first by introducing everybody. The panel is made up first of Sandra Jeske. Sandy is an arbitrator, special master, mediator, judge pro temp. She does complex technology, software, intellectual property, and business cases. She's a fellow of the Chartered Institute and chair of the North American branch. She's a member of the American Law Institute, and she's on the Silicon Valley Arbitration Mediation Center tech list, as are we all vetted tech neutrals. And she's neutral for AAA, ICDR, and CPR. She's also, which is particularly significant, has her undergraduate degree in computer science, as well as a master's in law degree. So Sandy, like the rest of us, have background in the substance of the matters that often come before us. Next is Jim Madison. Jim Madison is an arbitrator, mediator, referee, dispute review board member, and an expert in arbitrator ethics. And I've attended many of his ethics programs. He's a member of, he's a AAA in the multiple panels. He's a fellow of the College of Commercial Arbitrators. He's on our tech list at Silicon Valley. He's CPR Distinguished Neutral, California Resolution Council. He is an instructor in trial advocacy at Stanford, where he received both a civil engineering degree and his law degree. Pete Michelson is an arbitrator and mediator from the Michelson ADR chambers, which is his practice. He is experienced in a wide range of science and IT technology cases, like many of the others here, or all of us. He's on AAA. In addition, he's on WIPO and numerous other CPR, handled many ICC cases, member of the college, chartered. He's a chartered arbitrator and fellow of the Chartered Institute. He actually taught the class I took when I became a fellow. He's a chair emeritus and co-founder of the New York branch of the Chartered Institute. I said he's on the tech list. He holds a bachelor's and master's in electrical engineering from Carnegie Mellon, has an LLM in trade regulation from New York School of Law, and a JD from Duquesne. Finally, I said I am Michael Diamond. I've been a litigator my entire career and an arbitrator for about 35 or 40 years, doing mostly technology cases. My undergraduate degree is in engineering physics, law degree from Harvard, and I'm on the AAA CPR panels. I'm on the tech list. I'm a fellow of the College of Commercial Arbitrators and of the Chartered Institute As I said, Pete was one of my instructors years ago, and on various other tech and ADR organizations. Now, after all of that, that's sort of, I don't want to take any more of your time listening to our backgrounds. Let's talk substance. First, the first topic that we're going to talk about. Come on, guys. There we go. Is when and when not, and the when not is important to use a tech expert. Pete, I know you have thoughts on that.
Yeah. My experience, there are two situations, two primary situations where a technical expert is essential. One is where you want opinion testimony, and the second is where you want an education. And the latter is typically in the form of a tutorial. They're different, and they're different because in the context of an opinion technical expert, you want someone ideally who truly is an expert in the field, who has significant credentials, who is well versed, and hopefully has a reputation, because that opinion, to a certain, matters to us as arbitrators. We rely on that opinion. It's important that that expert, and we'll get into this in a short while, focuses his or her testimony on what matters to us as arbitrators, the questions that we would likely have. The second type of technical expert is in the context of those who present to us a tutorial. They educate us. Typically, even though all of us on this webinar are technologists, nevertheless, every arbitration we get is somewhat different. The technology is different. Yes, we can come up to speed quickly on the technology, but we need to be educated on it. And it's important in that context, at least in my opinion, to have an expert who can teach. It doesn't mean the person has to be heavily credentialed. It means the person has to teach. Because in my view, I have one opportunity to gain information from that expert. He or she appears before me once. I need that to gain as much information as I can from that individual. All of us have had experiences in college or graduate school or law school or what have you with professors who can teach, and it's a joy to be a student of them, and professors who can't, and they drive you crazy because you get frustrated. When we're dealing with a tutorial, and it's very important that the arbitrators are brought up to speed, we need an expert who can teach us, who is skillful. And that's very different than a person who provides opinion testimony. So let me pass it to my colleagues and get their thoughts.
And Jim, I'm going to throw it to you.
The topic of when and when not to use a technical expert brings up the issue of when do you engage the expert? I've had more than one case as an advocate in which actually engaging an expert even before commencing a defense or commencing a claim was productive, in that the expert was enabled to bring light to the issues in the case that have, in one case that I can recall, prevented us from undertaking a claim that was should not have been brought, and in another case, undertaking a defense that was not defensible. So that the education process is not only a process for educating arbitrators, but also can be a process for educating advocates.
Sandy? Oh, Jim, were you through? I'm sorry, I didn't want to interrupt you.
Were you done, Jim?
Yeah.
Okay, Sandy, your thoughts?
So one of the things that I see a lot is that I think counsel often tries to do too much with an expert. And I think that really comes from the fact that counsel, and I've been in the same role, in an arbitration don't fully appreciate the differences between trying a case in front of a court and a jury perhaps, and trying a case in arbitration. As Pete said, you know, if this is a technical case, I think we can probably assume that you've appropriately selected an arbitrator or a panel that has significant technical expertise. So therefore, it may not be necessary to engage an expert on certain issues that are within the panel's experience. And, you know, counsel, again, sometimes try to do too much with the expert. So if you're going to hire an expert, you're going to get them up to speed and have them testify, that's a huge expense, and it may not benefit the panel. So again, I think my key point here is make sure that you really select experts on issues that matter and understand the differences between trying your case in court and arbitration. And that is certainly one of them, the panel's experience and being very thoughtful in the issues that you present that expert testimony on.
Sandy just had to say.
I'm sorry, Jim, go ahead.
I was going to say what Sandy just had to say brings up a couple of footnotes in my thinking. One of which is, the expert should be tasked with testifying to what matters to the expert. And many of our cases, even though they involve technology, are at bottom contract cases or present other issues of law. And the caution is to prevent the expert from getting involved in testimony to actually legal issues as distinguished from technical issues. And relating to that, when we're, and this is kind of arbitration 101, but we don't need to go through a lot of the song and dance of introducing an expert in testimony in arbitration that you would in introducing an expert if you were trying a case before a lay jury. Because as Sandy says, we kind of know what the game is all about, and we don't need to go through certain drab preliminaries if you're presenting a case in arbitration, particularly a technical case, too technically.
Jim, I think those points are well taken.
Arbitrators.
I'm sorry. Let me follow up on one other point and things I think I've seen, and I know some of the panelists have seen, where you will have parties believe they have to have an expert on every single issue when the issues really aren't in dispute.
No.
And you don't need experts on both sides of those issues. And when you have a sophisticated panel in technology, you don't necessarily even need experts on all the background issues. And one way to streamline that is, and you can do this in arbitration, certainly you can't do it with a jury and probably not with a judge, is in conference with the arbitrators and counsel, is find out what is discussed with the arbitrators, what they are at the very beginning in the early scheduling conferences, what at this point they think they're interested in. Now that may not be, that may change, and that's not limiting what they would do, but it's sort of a mutual education process. So, I mean, on the extreme case, I give an example. I had one case where we had an accounting expert testified as to damages, not as to lost profits, but he simply added up all the elements that the other parties testified to. It was completely a waste of time. It was silly. You've also had experts testify as to, just basic science that we all understood. You've also had experts testify as to issues that didn't matter for resolution of the case. I mean, there's all kinds of things in a tech device or a tech process that are scientifically interesting and maybe interesting to experts. But if they aren't determinative of the case, we don't need to go there.
Springboard off the point you make, Michael, which I completely agree with, that is early on, counsel need to define the purpose of the expert testimony they seek. Because as Michael correctly points out, a good deal of it, at least in the context of litigation, isn't necessary in arbitration. And through the preliminary conference or an early conference in the process, be the first preliminary one, you can narrow down the need for an expert and focus that person on why.
Now, Pete, that's a good lead into the next topic. Okay. And that is, what types of experts are most persuasive? Jim, what are your thoughts on that?
Well, the PowerPoint that we have up gives kind of some of the headings on this. Obviously, and I think the negative implication about having experts who are knowledgeable in a specific technology or science, this particular issues that are confronting the arbitrators, tells us that expertise, specific expertise, is much more important than credentials. I've been an arbitrator in at least one case in which I think the counsel was ill-advised on the one side to sort of try to overwhelm the arbitrators with the extent of the credentials of the expert. And in that particular case that I can recall, the expert on the other side had much more modest credentials, but had much better knowledge of the issue that was confronting the arbitrators. And obviously, the question of the significance of the knowledge in terms of persuading the arbitrators prevailed over the weight of the credentials. Considering independent experts, I think in searching for an expert, start with the ranks of your own clients. Some counsel are apprehensive about putting on expert testimony from percipient witnesses who are indeed experts, out of concern that they the weight of the testimony might be discounted because of bias. On the other hand, if you have expertise within the ranks of the client, don't be afraid to utilize it. This gets us back to the issue we were talking about earlier. You may not need an independent expert if you have internal experts that will do the job.
And you may not be able to find an independent expert either, depending on.
Well, that's the next thing, is that searching for an expert, your clients should know the field. And to the extent that there are experts available, your clients, I think, is the first point of searching for an appropriate expert. And obviously, in the case of any other, whether it's a technology case or non-technology case, the same kind of due diligence that lawyers are expected to use in selecting arbitrators should be used in selecting experts. There are experts in particular technical fields that have their own agenda. They're not prepared to subordinate their agenda to the testimony with respect to the issues involved in the case. Those folks need to be weeded out, in my opinion.
I agree. Sandy, any thoughts?
Yeah, I think, again, we need to think about the differences between arbitration and being in court. And I think that this really allows an advocate to have more flexibility in selecting their experts, because there's no requirement that they be qualified under the rules of evidence. So they're not, and they're also not limited to experts who can really, break it down in such a way that they can explain these complex issues to a jury, because presumably, again, there's some experience on the panel of the relevant subject matter. So that allows the expert to focus on highly complex and technical issues. Going to Jim's comment about the independence of the expert, not appearing partisan is obviously something we would all desire, although it's sometimes a little more difficult to achieve. But, I think the most persuasive experts are those that don't overreach and, just try to put their expertise to a variety of opinions. If they don't have an opinion on a particular topic, sometimes you'll see experts who then try to, overreach. And it's much more persuasive if they don't try to stretch, because it really becomes obvious very quickly and can do sometimes more damage. So someone who is, has candor, believes in the opinions, and really admits what they've looked at and what they haven't, or what they are opining on and what they are not, I think is something that is a very persuasive expert.
Thanks, Andy. Let me throw a couple of other thoughts, following up and agreeing with everything that's been said so far, just from an experience in cases I've had. It seems to me that whether I'm the advocate or the arbitrator, that one has to be careful, I think following up on Sandy's comment in particular, that the expert is in fact testifying as to scientific facts. You've got two kinds of cases, I think, in technology often where you have opinion testimony. One will be, is this the best design? Is this a good design or not a good design? And there are multiple opinions on that. It's like, is the building architecturally built the most efficient way? I mean, there are multiple opinions. On the other hand, if the dispute is why did something fail, or did it meet specification, or how does it operate? Not how should it operate, but how does it operate? That's basic science. And you shouldn't have multiple opinions on physics or on chemistry. And I mean, I found that often my most persuasive experts, both to me and the ones that I've put on the witness stand as an advocate, are those who were academics who also have some who have practical experience too. I mean, most engineering academics also do industrial consulting, so they're not completely theoretical. But generally, the kind of people I hire, their first comment to me was, Michael, I'll look at this, but if I think you're wrong, I'm going to tell you, and I'm not going to testify for you. I'm not going to testify to what you want. I'll testify to what I believe. That is the key sign of a good expert. Somebody who will testify correctly as to the facts and not try to be the advocate, because the further out on a limb he goes, good opposing counsel and good opposing experts will simply eviscerate him and eliminate any value that he or she would have had. So you really want scientific, technical experts who are above reproach, who aren't advocates, but are telling it like they see it and have the background to understand it.
Michael, you're freezing.
I'm freezing.
You froze.
Still frozen? You're not.
No, you're fine. You're fine. I see you.
Fine.
Okay. The final comment is not to overreach, which is the same thing. I think it's very important that the experts stick within their expertise and not try to not only testify to what you're asking them to do, but then try to go and find why the side that they're testifying for should win and start giving, as I think Jim said, contractual arbitration. I mean, contractual interpretation. Why this fits with the contract or they've complied with the contract, as opposed to just what it is.
The corollary to the expert who is not going to go beyond the expert's expertise is finding the expert who is willing to do the necessary homework to prepare for the case. There are cases which the expert may actually even have to do some experimentation in order to come up with the opinion that is going to be helpful in the presentation of the case. And you need to make sure that the expert, whether it's reading or researching or experimenting or reviewing the remnants of a failed building, the expert needs to be willing to do whatever homework is necessary, and the counsel needs to be prepared to pay for the expert doing whatever homework is necessary in order to make an effective presentation.
Jim, that's really a very, very good point. And I've been in cases, this is an advocate less so than as the arbitrator, where my experts had, the issues were relating to failures of various components, and they ran the tests and we videoed the tests. So when the other side was giving us stories as to what we're saying was happening and when things would fail, we showed them they were completely wrong. I mean, we showed them, we redid the simulations, we did it, we had the videos with the real parts and showed them exactly how it failed. This was a jury case, and the jury, very unsophisticated people, but they found for us because we were right. And with an arbitration panel of sophisticated people, even the more so, where the first thing I think any of us look for is to see what did the expert do to come to his or her conclusion. Did they just, did they just read something and say that's the way it is? Or did they do the, if where necessary? I mean, there's basic science where you don't do experiments to prove basic laws, but to prove in individual cases where they have done the lab work and can show you they've done the lab work, that's very persuasive to me.
No, I agree with you, Michael. When I sit and I'm receiving expert opinion testimony, I like to have the support presented to me that underlies the conclusion, because then I can put credibility into what the expert is saying. Very important.
One other thing that was interesting, and I don't get this a lot, Pete and I sat on a panel last year, and both sides provided in their submissions numerous, without objection, by the way, so numerous scholarly research papers, the journal articles, which we spent a lot. I mean, this is a rather large case. This is a 9-figure case, but we spent a lot of time reading these journal articles, which persuaded us as to how we had to decide the case. I mean, interestingly, both sides used some of the same journal articles, but I don't know that. But our conclusions were based on what they submitted. Interestingly, more from the articles than from the experts, because the two experts were both very qualified and very honest. I mean, these are not people who we have any criticism of, but they didn't necessarily reach the determinative issue in this case, which was a contract issue. And the words of the contract were what we had to apply to the science. So they gave us all we needed. We certainly didn't do independent research, which would have been improper, but we took what they gave us, the whole mass of what they gave us, to reach what I think which I believe was the right conclusion. So again, focusing back, make sure the experts that they're knowledgeable, that are independent, they can support their opinions, they don't overreach, but that their opinions and the information they give you, as we said in the first slide, go to the actual issues that are determinative in the case. That's really how we need help. We need help in being educated, because every case is different, and there's always, and none of us are expert as the expert witnesses are in their area of science. We all have basic background information so we can at least understand the language and understand the general principles. We're there to be educated as to the specifics, but as to the specifics in particular as determines the case. So if you keep that in mind, I think you'll be safe. Next slide is how best to present all this stuff. And each one of these can be a 2-hour seminar. So we're just gonna start out with this stuff a little in summary form, and if there are any particular questions at the end, we'll try to answer those questions. I'm sorry, did I just change it? Yeah, I did. Sandy, you want to start this one out?
Sure. Obviously, you want to be able to present your case in the most effective way that's going to have some impact to the panel or the arbitrator. So how do you do that? I mean, the traditional format is a standard examination in each party's case, and that's what we're all used to. But again, because this is arbitration and this is really a party-driven process, you do have much greater flexibility than just, putting on the standard examination of one expert in your case and the next one in the other, and try to think as to what's most helpful to the tribunal and have that dialogue early. I mean, you could do witness statements with live cross, you could do hot tubbing, which I know will be discussed in a moment, examining experts separately, questioning by arbitrators. But I want to follow up particularly on a comment that Michael had about, science shouldn't really be disputed. And I think that one of the reasons that science or technology is often disputed between the experts is that there are differences between the opinions, often comes down to the underlying assumptions made by the expert. And if you have two experts who disagree on just even sometimes a single assumption, it can lead to wildly divergent opinions. And the tribunal is then left to figure out which expert is right, how to decide this case. And one way I would suggest to address those kinds of issues, to really getting to the crux of it, because this is supposed to be this efficient and cost effective process that we have, is to have the experts together meet to narrow the issues and determine which issues are in dispute and which issues are not. It makes it very clear then to the tribunal how the assumptions are different, how each expert came to an opinion, and that could, again, flexibility is king in arbitration. That could result in, say, a joint expert report with a list of the agreed upon topics and those that are in dispute. That would reduce the hearing time, make it more efficient, and certainly provide a great deal of clarity to the tribunal.
You know what, Sandy brings up a point that kind of loops back to where we began our discussion, which is when to use an expert. And I'm thinking from a temporal point of view. It's not only when to use, when to select, when to engage an expert, but also when to engage the panel in the use of experts. Over the course of a preliminary hearing, maybe multiple preliminary hearings, zeroing in on the issues and zeroing in on the manner in which the experts will be of assistance in the panel reaching its decision is certainly a worthwhile subject to be brought up not only once, but more than once until you reach something that is going to be most productive when you're in discussions between counsel and the panel.
Let me jump in on Jim's comment because I agree with him completely. The difficulty that at least I have, and I mean, all of us who sat as arbitrators have, is we want certain information from an expert, but do we know enough to ask a question, or what happens is do we learn enough, and then by the time we get that information, is it too late for us to raise the question, so we have to go off and do something else? Jim's point is a very good one, in the sense that maybe it makes sense to have multiple conversations with counsel as the arbitration proceeds along, so that we as the arbitrators can get our questions out to the experts, and the experts can then respond to our needs. Because at the end of the day, we need to get information from them. We need to be educated by them. They don't do us any good if they don't answer the questions that we want to answer.
Let me follow up on a couple of the comments, and this is simply one of which is, and it was Sandy said, and I think it was, I would underline it in red and put flashing lights on it. The underlying assumptions that the experts are using are key to coming to different conclusions. But sometimes it's not just a scientific assumption, it's the information provided to the expert by the party and counsel. So the biggest red letter warning is, be really careful that what you provide the expert is accurate and doesn't leave out key facts. I mean, I've been involved in cases where where you had a very honest expert who came to a 180-degree opposite conclusion from one of the parties. And when the party gave that expert in the hearing the additional information that was undisputed, he completely changed his testimony because he was both honest and knowledgeable, but hadn't been given the whole story. Given the whole story, he completely, it wasn't that he was impeached. He said, no, based on that, and he changed his testimony. You don't ever want to be counsel in that situation. It is embarrassing. Not aside from being embarrassing, I mean, you lose, and which is what happened here. So it's very important that the appropriate, doesn't mean you have to give the expert all kinds of information that's extraneous, but what's given to the expert has to be both accurate and has to be complete. There can't be some fact that can get thrown at him or her at a hearing that's going to change the testimony. And you know, if you have a very honest expert, somebody who's really knowledgeable and isn't just an advocate, an expert can correct for that. I mean, there was one, or correct even for his own errors. I was involved in one case where where a mechanical engineering expert who was a professor and a very fine guy, I mean, had done a calculation about the cause of a brake failure. And he made some calculations, and they pointed out, and they showed why a particular spring didn't have enough what force the spring exerted, and it wasn't enough. The other side, very good lawyers, pointed out that he hadn't included a 1/4-inch washer in his calculations, which A, was embarrassing. But he went back over lunch and redid all the calculations and found, yes, there was now a little more pressure than he had calculated, but it still wasn't enough. Instead of saying, I don't make, I'm right, you didn't have to conclude it, he said, yes, oh my goodness, that's a mistake. Let me look at that again. He did it very academically. Let me look at that again. And did the rest of the calculations, and his testimony was even more effective. So it's very important in the technical world that there be credibility and integrity. The other topic, I'm going to flip to something. The other topics here is just how do you put it down? I mean, you can always do it the standard way, but as Sandy said, arbitration gives you opportunities. If you're doing international, you're going to have witness statements. You're not even going to have direct with live cross-examination. And you need to prepare for that. And you need to have the witness statement be effective. Sometimes witness statements are written by the lawyers, and the arbitrators see they're written by the lawyers and don't really address the things as you'd want them addressed. The hot topic.
That can be done not only in excuse me for interrupting, Mike, but that's something that can be done not only in international, transnational arbitrations, but also in domestic arbitrations. As a matter of fact, you can go to the extent of if it's a situation in which experts are going to prepare reports, many times the report, or not many times, but at least in some instances, the report can stand as the direct testimony of the arbitrator, of the expert. And we go, the question then becomes the sequence in which you present the experts, so-called.
No, it's good. You're absolutely right, Jim. You're absolutely correct.
Consecutively.
I want to move on in just a minute, but 2 more comments. Hot tubbing, is anyone who'd like just to talk 2 minutes on hot tubbing? That's a whole seminar that we're going to be putting on, that's being put on in several places, one of which is the New York International Arbitration Week, which will be available to people. But hot tubbing is a real issue. And I think it's also, we have another Silicon Valley program on that if you look on the website. But you want to just hit on it quickly, Sandy?
Oh, no, I think somebody else, I haven't actually done hot tubbing, so I'll let somebody else speak to that.
I haven't either, but I have done particularly in some cases it depends on whether the experts are coming at the issue from the same perspective.
Jim, can I interrupt you for a second? Just so everybody knows, hot tubbing is when you have both experts essentially together in the room and can be questioned and examined together and can talk to each other. Right,
I'm very much a fan, although I've never used hot tubbing, I'm very much of a fan of having experts who are on the same issue testifying consecutively, so that you are focusing on that issue and you have the competing opinions to the extent that there are competing opinions in focus so that at the same time, rather than one lagging the other while one side is putting on its case and the other side is then putting on its case.
The final topic here is questioning by the arbitrators, and I'm going to talk about that just for a second. The counsel should be prepared, as should the experts, that the arbitrators may well have questions, because what we are trying to do, and everyone I've ever sat with has tried to do, is get the right answer, not declare winners or losers in a moot court competition on technique. This isn't arbitration isn't a game where you win on style points. We are trying to come to the correct legal and determination based on the facts as we can understand them. So we may well have questions to follow up with the experts, so that to clarify holes in our understanding and confusion. So just be prepared for that. Right, I'm going to go. Let's go on to the next.
Michael. Excuse me, Michael. Before we leave that, though, kind of arbitration 101 is counsel puts on examinations, cross-examinations, that arbitrators have questions, and then counsel will get the last word. But when you get into technical issues, and when arbitrators get involved in questioning, it can become a Socratic process where the arbitrator may have a question of an expert and the expert may have a response which may lead to another question and so forth and so on. And I don't think counsel who are presenting cases should be at all concerned about that sort of questioning proceeding from a panel in a technical case.
Jim, and also the expert should be prepared by counsel to expect that, so that doesn't come out of left field.
No, that's absolutely right.
Particularly if this is their first, their first rodeo.
Yeah, the point I want to make here, which is consistent with what both of you are saying, I want to be sure I understand the expert. I want to be sure the expert is communicating to me effectively. I'm not the least bit inhibited about asking a question. I won't ask a question because I'm assessing credibility. That'll come later. I ask a question because I want to understand. And if something is unclear to me, that expert is going to be before me once. And so I want to make as much use and take advantage of that person's knowledge as I can. Asking a question to gain clarification is something I do regularly.
I just want to add to that. I mean, I agree. I think sometimes counsel are very shocked and almost put off if an arbitrator asks a question. And at the end of the day, we have to make a decision and we have to understand it. And if we are asking questions, it's because something is not clear in our mind and we're trying to understand whatever the issue is. And it is not in any way to suggest that we are, siding with one side or another. It really is just, we have an obligation to understand this case and to make an appropriate decision. And it really is just fulfilling our obligations to understand the issues.
And make sure the expert knows that we're likely to ask questions. I had a case several years ago, a 9-figure case, where I asked a question and the expert just froze, because the expert just did not know how to deal with it, just froze, melted. So as counsel, make sure your expert understands that we may have a question and don't be fearful of it. Answer it, that's all.
All right.
Okay.
So we've gone over some of this already. No, I'm sorry, wait 1 second, I thought I changed it. Why aren't we changing? There we go. We've gone over some of this already, but in summary, I mean, consider your arbitrators when you're selecting them and when they're there. I mean, if your arbitrators, if you have 3 tech arbitrators, but their technology background is like Pete's and mine, or for that matter, Sandy's and Jim's, while we've done lots of biotech cases, our degrees aren't in biotech, aren't in biology or biotech. That's different than dealing with those of us if you're dealing in an electrical engineering case or in something where we may have more in depth. So figure out who they are, and quite frankly, that's part of the dialogue that he talked about earlier. Talk with the panel about what they do need and what would be helpful. And how do you, and again, we talked about, Pete opened up with this, but sometimes rather than going into arguing the case, having the background provided to the panel very early on. Maybe you just do it by a written joint background report. I mean, we were in a case recently where we had a very complex technology, and both sides did. It was in 2 phases, and both sides in the opening phase did a very, very good job of explaining the subsequent the technology with videos and without testimony, which the lawyers were very knowledgeable testifying to it. But the fact is, we didn't need both of them because they both said the same thing. Both were very helpful, but they could have saved time and saved money if they just agreed on a quick joint presentation with the same set of slides. If you need an expert, maybe they can agree on one expert to provide a joint tutorial. If there are agreed background articles that would be helpful to us, submit those to us jointly. That'll save you. That'll make the whole process more efficient. That's not necessary in all cases. It may not even be helpful in all cases, but where it is helpful, that's a really good thing. And then ask the arbitrators, even if they don't raise the issue, ask them, do they have any questions? Is there something else they'd like to know? Sometimes there are some arbitrators, unlike the 4 of us, who are shy about asking questions unless they're asked to do it. Not all arbitrators ask questions, and they're very good arbitrators. But ask arbitrators if they have an issue. Yeah, and we'll get to the last one last. But anybody else on the panel here have a comment on these particular issues?
I just want to emphasize the point that, you know, arbitration is designed to be efficient and cost effective. And to the extent that you have arbitral rules that apply, they're designed for that process. So as arbitrators, we have to conduct the proceedings with a view towards, you know, expeditious resolution of the dispute, facilitate efficient and cost-effective management, you know, and you'll see that whether it's AAA, ICDR, the UNCITRAL rules, I mean, go on and on. All the rules are designed to be like that. So I encourage you as counsel in these cases to be creative, be thoughtful, be flexible. This is not, you know, in court. And so the goal here is not to hide the ball for the arbitrators, but to, you know, really try to zero in on those issues as we talked about before. What are the differences between the experts' opinions, and how can we make the tribunal understand those, and just try to think a little differently. And I know it's very difficult, and certainly I've been counsel in a number of arbitrations as well, and it's hard to get out of our typical mold that this is the way it's always done. But just think about how much more flexibility you have in this kind of setting, and B, how much more efficient and cost effective it can be, and how you really have such an opportunity to crystallize the issue that you wanted to focus on before the panel.
I mean, think of the arbitration.
Sandy brings up the
blank piece of
point.
And counsel,
as arbitrators, have a reciprocal obligation to work with in any particular case in being open to creative processes that will advance the arbitration in a cost-effective and expeditious manner.
Pete, you had a comment?
Yeah, basically it is similar, if not, and so springboards over what both Jim and Sandy just said. And that is, think of the arbitration as a blank piece of paper, which litigation is not. You can conform the process as counsel to just what you need and not more. In the sense, as I say, you can fit the process to the fuss, and you can tailor it. And you can certainly do that with experts. You can make a very, very efficient process. Keep that in mind. It requires a bit of creativity, and you have to break out of the litigation mindset to do that.
Well, let me reinforce what both Pete and what all three have said, and a little bit differently. One thing that I think we all see, and I've got some matters right now that I'm seeing it again, is lawyers should understand they're not in federal court. This is not a federal rules pleading. When you're stating your case, just state your case in paragraph form. When you're giving your answer, just state your defenses in paragraph form. You do not need to go denied, admitted, accept, denied, accept. And you just waste a lot of paper. That's number one. Number two, if there are disputes, whether the discovery, expert discovery or otherwise, first try to work them out, then we'll try to work them out with the arbitrators rather than filing 30-page briefs. I don't allow that to be done in my scheduling order. And if you're going to have to file a brief, file your brief, but keep it succinct. You don't have to start with square one every time. You don't have to fill pages and pages and pages with stuff you said before. We want to keep it efficient. Well, it's interesting. There are parties and companies who are very opposed to arbitration because they say it's just as expensive as going to federal court. Only if the lawyers make it so. It absolutely doesn't have to be. It's up to you. It's your process. We'll work with you as arbitrators to keep the costs down and to keep it efficient. You're not going to be prevented from making any point, from providing any evidence, providing any argument. But all the formalities and the time-consuming processes can be avoided by simply working in a collaborative process. It's a blank piece of paper, as Pete just said. We can work with that. By the way, last topic here before we go to questions, I got a quickie on the next slide, but it's not particularly substantive. Is the concept of tribunal-appointed expert is very common in civil law countries in Europe, where there is a neutral expert, not appointed by either party, but appointed by the tribunal. Usually it is the tribunal will clear that expert with both parties. They won't do it because the parties are going to pay for it. So you will try to get, they'll get somebody that both parties agree, and that's generally to provide as much background as possible. Not necessarily, but I assume in Europe they do it sometimes, but I don't think we Americans would be into that, to have them give ultimate opinions on the case, but at least providing the background. A tribunal-appointed expert or a jointly appointed expert, which is essentially the same thing, could be very helpful and could save everybody a lot of time and money.
Yeah, the international rules provide for decision-making experts, which I think is would be unprecedented in my experience domestically. But having an expert, the very first life science or biology case that I got involved with, there was an expert, actually only came from one side, but the function of the expert was simply to provide an education, if you will, to the panel on the fluid dynamics of blood. None of us were familiar with leading into the arbitration, but that was the only particular function of this particular expert, was to explain, as I say, the fluid dynamics of blood and its respective components, which is kind of responsive to a question that I see Les Scheffelbein has raised, which is, engaging an expert, whether it's at the instance of the panel or at the instance of parties, to just simply provide a basic education to the panel in matters with which the panel, albeit technically qualified in general, does not have specific knowledge about. I think that's a very wise thing to do, and a very wise consideration for panels to initiate if the parties have not anticipated that.
Okay, the last slide is really a summary. It's sort of a summary. It just talks about common pitfalls, things to avoid doing. Pete, any thoughts on these?
Well, I think certainly we've addressed the second topic on this slide, but I'll reiterate it, and that is, you don't want your technical expert testifying on a legal issue that the panel has to decide, because the expert has no expertise in that area. And to some extent, that'll raise a credibility problem in terms of the expert going beyond the remit, shall we say, of the technical issues in front of him or her. So the expert needs to focus on the technical issues, that is why the expert is there, right? And in terms of the first topic, I think it's basically pretty self-evident. From you establish the technical issues, you establish a background, you establish a perimeter, if you will, as counsels to what you want that expert to talk about, testify about, and not go beyond. Sandy,
I think we, unless anybody has any further comments, I'm gonna go to the questions in just a moment. But I want to go to the. I'm gonna have to go to the next slide for a second, which is everybody. This is a list of various resources, rules that cover the topics from various organizations that we've been discussing today. The slides that we've been looking at will be sent to everybody who participated, all the attendees. So you will all be getting that. And now I'm going to get out of the screen sharing, and I'm going to look and see what questions we have. Q&A. I got 5 questions. No, the first one, actually a couple from Paul Mason, wants to know what we think about tribunal appointed experts. And I think we've covered that, but now the second one's interesting. What about small startups who can't afford outside experts? And the thought of using only internal experts. is that going to affect your decision making if they're only internal people?
I mean, certainly there is some view that they're not independent, right? Which we talked about. But, you know, I've seen them, I've used them, and sometimes it's just the right decision. It depends on the case, but obviously it comes with the risk that they are not going to be perceived as independent, which, you know, should come as no surprise. But I've seen it, I've done it, and, you know, I think that there are times when it makes sense, and it certainly is more cost effective and efficient process to do that. Just, it comes with those known.
It greatly depends on the quality of the knowledge of the internal expert. So if they come across as knowing their onions, so to speak,
Yes,
they will be credited, even though they come with the jersey on of the party that is employing them.
and as arbitrators, we have the ability, through our experience, to deal with questions of independence, to assess credibility, and to filter out, if you will, any prejudice or bias or lack of a defense that we may see. You know, I see nothing wrong, John, springboarding off the comments of Sandy and Jim, using an internal expert, because A, it's very cost effective, and B, they may be the only people you can find. Their expertise may be so narrow, there's nobody else out there that has expertise similar to what they have.
All right. The next question I think is a really good one. The next question isn't a repetition of anything we've discussed, but how would you handle unqualified experts or junk science? Misrepresented credentials before or during the hearing. Now, I think it's directed at, do we not hear the testimony, or what do we do? What are your thoughts?
Well, I think you hear the testimony, you just give it whatever weight you think it's appropriate. And if the expert is basically unqualified, you're pretty much not going to give the testimony much weight at all.
Any other thoughts on that?
I mean, agreed. I mean, we're not bound by, or we don't use the strict evidentiary rules on qualification of an expert. And so therefore it comes in like anything else, but, you know, it will be given the weight that's deemed appropriate. And I'm sure that the cross-examination will make it very clear that this person is, you know, misrepresenting their credentials or in some way not qualified.
I completely, Bill, I'm sorry, Jim?
This is something that, you know, if you are an advocate in a case and the opposing party has disclosed an expert, you do want to do your homework on that expert.
Really do.
Yes. You know, it doesn't hurt to, you know, start with Google and go beyond that, because it may be that you as counsel bring out the fact that if there's a misrepresentation of credentials that undercuts the basic expertise of the expert, bring that out in advance of a hearing, and you'll find that maybe it's crucial to producing a settlement in the case. So don't be afraid to do homework on an opposing expert.
I think that's actually I'm sorry, go ahead, Pete.
I was going to say, with the internet being what it is these days and being a permanent repository, if there's any negative information on an expert, likely it'll be on the net and it's going to come out. So given the comments of my colleagues, deal with it sooner than later. Because if you don't deal with it, your opposing counsel will.
Right, but I completely concur with everything that's been said, but what Sandy said is correct in my mind, is that, let them put it in, because I think the one thing you don't want to do in arbitration is give somebody the argument that you haven't taken in evidence, and then they play with vacature, particularly with an expert. It's just as easy to take it, and you know, I tell lawyers, young lawyers on training, and when you're in an arbitration and the arbitrator says, "I'm taking it for what it's worth," you know it ain't worth much, but don't get upset that he took it, because or she took, you know, that he or she took it, because you just, I mean, unless it's completely scandalous or outrageous, there's no reason to mess with the record. Just put it in and you ignore it. I mean, I'm sure we ignore a lot of stuff that goes in that just that isn't relevant on the point. Another question is expert report. Okay, well, I want to answer another question. I would like to answer another question if we could. I want to see if we can get through these. There are a few more questions. I'd like to get through them if we can because we're running out of time. So keep your answers really short. What are people's thoughts about getting expert reports? Should they be simultaneous? We've already said that, should they be used as direct examination? Jim raised the issue that that's basically can be the witness statement or the direct examination. But what are people's thoughts about requiring expert reports, and if so, should they be simultaneous or consecutive?
Again, it goes back to what's the most efficient way to deal with this case, and I think it could be fact dependent on what the expert testimony is. And one of the things that I think that maybe we haven't talked about as much too is, really there should be an early discussion about where expert testimony is needed. I mean, I know we've touched on it a little bit, but I think that early discussion with or without the arbitrator will help crystallize how you're going to handle these experts and such. Again, we're not here to check boxes of process. We are looking for the most efficient way to handle the case. And presumably the most efficient way to handle the case is probably simultaneous exchange, rebuttals if you need them. But again, you may not need them. And I don't think that depositions are necessarily necessary either of an expert. You've been given the disclosure of the reports,
I've never permitted expert depositions when there were reports. That's my practice. I think it's just one more way to spend time and money, and that is unnecessary in arbitration. Second, I got two more questions, and then we'll wrap it up. One question is what's the experience, and I think this may really go to Jim, who's done a lot more construction. What's of presenting expert evidence in the form of a site visit, explaining the working of a machinery, or presenting evidence with the help of a technical sketches and diagram?
The short answer to that is the more the merrier.
Yeah, that's fine.
Arbitrators need the information. They should have all the relevant information that would help them decide the case and reach a fair decision in the case. And if a site visit will help,
do it.
Would go for a site visit.
Do it. Yeah.
Diagrams,
by the way, drawings and models and all of that kind of stuff is only helpful.
Yeah.
Photographs. I mean, whatever it takes, so we understand what happened, or how it worked, or how it should have worked.
Pete mentioned video, or Mike mentioned videos earlier on simulations of post-accident simulations. If we're talking about a failed component or a failed building or something of that sort.
Last question, and then we'll thank everybody and break. We're asked to address the use of industry experts on commercialization of products, meeting commercially reasonable efforts. Anybody have any experience or thought on that? I do not. I mean, that hasn't been. I have not had a case like that, so I can't talk to that at all. But can any of you?
Oh, Jesus, I just got off here somehow.
Well, you're back on, Jim. We hear you. Pete, can you hear me?
Yeah, if it's my view is if it's an issue that requires
we just lost Bill.
Technical expertise, then bring in the expert to deal with it. I mean, I see no harm in it.
Jim, you're back. Did you hear the question?
No. I was, again, you've got the appropriate expert can very well have an opinion on that subject.
As long as the opinion is relevant, if it's a substantive opinion that's relevant to the determination of the case or to our understanding of the case,
bring it on.
Absolutely. Then absolutely. I mean, you don't want to keep that out. All right. That's the end of the questions. I want to thank Sandy and Pete and Jim. I want to thank Bill Seward at Silicon Valley Arbitration Mediation Center, who's our administrator, to make this thing go so smoothly. Thank all the questioners. I hope this was valuable to people. And if there are any more questions, I don't see any more questions at all. So it is 1:05, and I'm going to call it an end. And again, thank everybody. Although I do have a bunch of chats here. Okay, I've got, here, let me take 5. I've got a bunch of chat comments that are actually interesting if people are looking at them. People are talking about hot tubbing that is, apparently it's common in Australia.
We talk about it a lot in this country, but you don't see much.
Yeah, I know. It's in lots of the seminars. It's in lots of the seminars. We see lots of it talked about. I have not had it done. And I think lots of lawyers are very hesitant to want to do it. So as an arbitrator, I've not seen it.
I've had cases in which experts on opposing sides comment problems from different philosophies or different approaches. Right. And, you know, you just don't gain anything by even venturing into hot tubbing in that kind of a situation.
Okay.
This is not technical, but just evaluations. One expert uses one process in reaching a valuation opinion. The opposing expert uses a different process in reaching a valuation opinion. And you need to hear both opinions, and you need to hear both processes, but hearing them while the experts are side to side and having their own discussion over it, I think does not advance the ball.
All right, and again, let me just give one final commercial for those who are attending who aren't previously familiar with the Silicon Valley Arbitration Mediation Center. We're a nonprofit that has really 2 goals. One, to vet tech neutrals for arbitration and mediation, and you can, and they are placed on our tech list. We also promote ADR in technical cases, and we have a general membership of people who are not arbitrators or mediators, but are supporters and general members. General members get to attend all programs, either a discount or free. There are a number of benefits. They're all available on the website, www.svamc.org. And you can look at the tech list and see who the tech list members are. You can look at lots of articles that are posted, and you can look at all the upcoming webinars and events that we are either promoting and sponsoring on our own, or we are co-sponsoring with other organizations. And we do a lot of co-sponsorship with every arbitral organization around the country and around the world, from Asia to Europe and all over the US. So again, Sandy, Pete, Jim, thank you very much.
Thank you, Mike.
Have a great day.
Take care. Thank you.